So the changes that have been implemented so far under the Employment Rights Act, which became an act in December 2025, and has been debated for a long time in Parliament. The ones that I'm going to be dealing with today, not everything in the act has been implemented so far. They're doing it in drips and drops. And some of the changes have been done since the 6th of April this year. A major chunk of the changes is going to be done again in October 2026. And then we'll see again some changes that will happen in 2027. So we are just going to be touching on the changes that have been implemented so far. Whatever I'm not commenting on today is because it's not yet implemented. And as they'll be implementing, we will be doing further webinars. And also, case law is going to start coming out because people are going to start challenging each other in tribunals and in court and so forth. So we will be dealing with case law as it starts to develop a new jurisdiction of law. So we will have new cases that will be coming out. But one of the changes that have been implemented so far is that statutory sick pay is now a day one right. From March this year going back, statutory sick pay kicked in on the fourth day. An employee was not entitled to statutory sick pay in the first 3 days, so they will be unpaid. But the government has said that they want people to take time off when they're not feeling well, because some people would, according to the government, come to work because they are afraid to lose their salary, or at least the reduced salary which they get under the statutory sick pay. But then they've made this change to say that people can get their statutory sick pay on day one. So starting April this year, the 6th of April this year, an employee is entitled to statutory sick pay. That's the minimum that we have to pay them. Some businesses, as we know them, have got occupational sick pay or other enhancements that they do, even if someone is not feeling well. But so that you will not be caught breaching the law, make sure that you've adjusted your payroll, you've adjusted your policies, you have informed your staff that they are now entitled to statutory sick pay from day one. Another thing that is important to note is that they don't have to have worked for you for any particular period. So someone can get statutory sick pay even if they've started working today and in the afternoon they start to feel unwell, then they'll be entitled to statutory sick pay. The only thing that the law says is that they should have done some work for you, and then they will be entitled to statutory sick pay. So from experience, having dealt with companies, having gone into audits where we audit a number of businesses, we see that some people take genuine sick days or sick time because they are genuinely not feeling well. However, that has also been open to abuse with some staff that will phone in sick because they don't want to attend work. Particularly with some of our clients in the health and social care. If someone doesn't want the way the rota is done that week, they may call in sick or give any other reason why they're not coming to work. So maybe as employers, we need to consider our working environment, our working conditions, the flexibility of our work, and so forth. If it is something that is causing some of our staff to then phone in sick because they are not happy with the working conditions or the working hours and so forth. But the main point here being that take note that statutory sick pay is now a day one right. So if someone falls in sick, then they are entitled to payment straight away. Off my head, statutory sick pay now is around £123 per week off my head, but you can double check that on the gov.uk website or with your HR advisors. So another change that has taken place is the paternity leave. Previously, someone had to wait for 26 weeks before they would be entitled to paternity leave, 26 weeks being 6 months. So they would have worked for you for half a year for them to be entitled to paternity leave. But the law has changed. Even on the first day, they are now entitled to paternity leave. This, the government says that it will enable fathers and partners to obviously attend to their family when there is a young one born into the family, and that then they'll be entitled to it. This is a paid leave as well, paternity leave. They will be entitled to paternity pay um, in line with other benefits that they might have. So, what should we do as employers? We need to update our policies. We need to make sure that we've got adequate notice procedures and also train our staff regarding the management of paternity leave. I don't think that that will be a lot of people going on this, but taking into account that there is generally as a country, people are not really having so many children as maybe in the past, as in the boomers back in the day. But it's something that we need to know that paternity leave is something that people are now entitled to on day one. Um, Then again, unpaid parental leave, which can be up to 18 weeks. So it's now again a day one right. Previously, someone was not entitled to unpaid parental leave if they'd not given us a service of 12 months. But now they can be entitled even on day one. It's unpaid parental leave. But even if it's unpaid, we know that it's still a cost to the business because if someone is away on unpaid leave, you still have to employ someone to come in and cover their work. But they are still that employee that is away is still on your books, and that might be costing the business one way or the other. That's a cost that the business should be able to consume and to take care of. The government said that this reform is intended to improve flexibility for working parents and remove service-based barriers. So the requests, as we hear from people, they are now coming in where people have got young children and unfortunately, where someone is a parent, things do happen in the way maybe children has fallen sick or the school have just called you in to come and collect them and so forth. So we need to plan our workforce. So I always say to my clients that we need to have um, an extra allocation of stuff that we might have because if, for example, the workforce that we have and the hours that we have is for 9 people, you might consider having maybe 10 people, some of them being part-time, flexible workers and so forth, so that if someone is away, then you are not caught unawares and you are not caught unprepared because someone has left employment for whatever reason that they have. So it's important that we sit down and plan our workforce so that we do not have shortage of staff. But shortage of staff has got other implications that we do not want in our businesses. So the bereaved partner's paternity leave is something that is also kicked in. It's entitlement up to 52 weeks of leave for a surviving partner if the mother or primary adopter dies within a year of birth or adoption. It is again now a day one right. But the leave must be a continuous leave for just a single block, not in chunks. So that 52 weeks should be taken as a single block. If someone does not take the 52 weeks, they take 2 weeks, they take 3 weeks, 6 months, then they cannot retake it again, the period that is outstanding. So this is a statutory unpaid leave, although employees are legally protected from dismissal or rejectment during the period. So these are some of the things that are interesting, especially for those people that are having staff that are on the Home Office sponsor license, because there are some things that the employment law advocates for, which the Home Office does not necessarily think about or have not considered, which then comes in a more like a conflict between the laws. Because under this one, this is a legal entitlement, so they can have this leave, but the Home Office might we have to consider what happens if the COS, the certificate of sponsorship, comes to an end, for example, and the implication on the business, etc. But in terms of the employment law, which is my focus today, someone is entitled to 52 weeks, 1 year of bereavement, because they are now taking care of um, their child because one of the parents have taken have left, etc. So that's another change that is taken in, and you have plans, you have to have policies, you have to inform your staff about how you can handle and deal with these things as they arise in your business. So the government has also established what is called the Fair Work Agency. So previously, from March going back, there were quite a number of departments, organizations, uh, government um, extensions, etc., that were there that were dealing with different um, aspects of employment and enforcement. But the government decided that it's better to put them under one organization or under one big body, and they formed what is called the Fair Work Agency. And this Fair Work Agency includes enforcement agents such as the Employment Agency, the Standards Inspectorate, the GLAA, which is the Gangster Licensing Authority, the HMRC minimum wage, etc. So now they are now working under one roof. Previously, they were saying that if they're investigating, then information was not passed around properly, and you could have so many different maybe investigations by different departments. But now everything is under one roof. So for those ones that have dealt with these organizations, you might have received correspondence to say we are now being migrated to the Fair Work Agency, and whatever is happening will continue, no changes, and so forth. So the other point why the government had to form the Fair Work Agency is that they want to make sure that they really implementing the changes, or at least they're enforcing um, the law against anyone who breaches. So we might see that there's going to be a lot of enforcement. We might see that there's going to be a lot of investigations that is going to happen. So that is why it is important for us as employers to be compliant, because the government intends on enforcing the law. The penalties vary which the fair agency can give. It moves from civil enforcement, criminal enforcement, um, things like fines, etc., action plans, and so forth. They've been implemented. If you have got time, you can read this document. It's about 27 pages, and I think it's important for you as an employer to read it. You can search online. The document is called the Fair Work Agents Enforcement Policy Statement, and you can read for yourself about that. So just again, make sure that you have audited your employment records, your payroll practices. And this is quite important for those people that do their own payroll in-house. So just make sure that you are compliant and holidays. From my dealing with employers, I can see that some employers do understand these things. Some people don't. When it comes to holiday, some don't give the holidays that they're entitled to their employees. Some they do give over what is really necessary in terms of the employment contract. Some don't even know what the employment contract says. So it's important for us as employers to be aware and to know what our policies and documents say and update them as necessary. Again, another important point for employers, especially when it comes to record keeping, is that it is now part of the requirements. It's not, left to the whim or to how the employer personally was going to deal with their own record keeping. Now we are now mandated to keep certain records because if you don't, then it might amount to a criminal offense or a penalty that will be dealt with by the Fair Work Agency. So employers must keep adequate records of annual leave and employment and holiday pay for 6 years. So the minimum period that you have to keep this period, this information is 6 years. So if you are using an Excel spreadsheet, or if you are using a hard copy notebook, or whatever you are using, make sure that you've got a way of retaining this information for about 6 weeks. And these days, there is a lot of software that is available, a lot of platforms that you can use for your HR. I would advocate for people to use those softwares. I do know and understand that some people still prefer the old ways of, for example, having a rota put on not a white board in the office, or is it put on a small paper in the office, and people can go and look for the paper and so forth. With the times that we're living in, it's kind of now outdated. You need to have some software. As Tanlo solicitors, we've partnered with Breathe HR, which is a software that we advocate for. If you want to know about them, you can contact us, and then we can direct you to Breathe HR. But you need to be keeping your records. If you are investigated and the records are missing, then you will face a penalty. So what should we do? Check whether our systems record entitlement, accrual, leave taken, holiday calculations, etc. Implement a 6-year retention progress, audit existing records, and address any gaps that are existing. So collective redundant protective awards doubled. What has changed is that the maximum protective award for failing properly to consult in collective redundant situations increased from 90 days gross pay to 180 days. So in a nutshell, where you were doing collective redundancy, if you were making people redundant, you are supposed to follow certain steps. Depending on the number of the employees, you might have to do consultations, or you might have to do individual consultations. And if you don't do the consultations or follow the process, and you are found that you have not followed the process, then the employees might be awarded a redundancy of now 180 days, which is 6 months' salary for your breaches of failing to follow redundancy. And I'm afraid to say that, especially for my colleagues and friends that are in the health and social care, for whatever reasons, there's a lot of redundancies taking place because if someone, for example, had 180 hours, for argument's sake, per week, and they've reduced because the staff, the clients or service users have been taken away, and then now you are merging, or you're selling, or you are getting rid of your business, and then there has to be chopping and redundancies and so forth. Some people are not following the proper procedures, and you might be liable if you do not follow the procedures to be paying a penalty of 180 days salary to the staff because you have not followed the procedures. You need to be able to follow the procedures. If not, maybe you might need to take corrective actions if you have been in such a situation. And the increase is intended to strengthen compliance and deter procedural failings in collective redundancy exercises. And some employers would do it deliberately because they want to avoid payments. But if you do that now, it's now more penalties that you will face. So employers who are approaching restructuring involving 20 or more employees with greater caution. Let me retake that. Employers are approaching restructurings involving 20 or more employees with greater caution because the financial exposure for defective consultation is now materially higher. So you need to be careful about that. You need also to follow the chopping process. Chopping process, if you've got a sponsor license, will also need to be followed with the Home Office. And if you didn't do it properly, the Home Office will want to see information like the ELI and so forth. And if it's not there, then you might have to retrospectively redo it again to be compliant. Okay. ACAS. ACAS is an organization that is there to do mediation between the employer and the employee in case of a dispute. And now the dispute is now potentially going to go to a tribunal, the employment tribunal. The courts in general would want people to mediate and not to go for litigation because litigation takes a lot of time and litigation is expensive. And the courts are there to try to resolve issues earlier. And that is why we have got the ACAS, the early conciliation, which is available. So the period of the conciliation has been extended from 6 weeks to 12 weeks so that there will be more time for people the employer and the employee to try to negotiate and to try to come to a resolution. And when we do consult with our staff who are about to be taken to a tribunal, we have to be pragmatic and we have to give them advice that makes commercial sense. Sometimes if an employee is suing you for say a month or 2 months, whatever salary that is outstanding, and maybe you believe you are right as an employer, sometimes it will be more pragmatic to just settle and avoid any further cost in terms of legal costs, delays. And you have to bear in mind as well that if an employment tribunal makes a decision against you, that decision, not necessarily against you, rather, if an employment tribunal makes a decision in the court, then that decision is publicized on the GOV website. So you might have your company listed on the GOV website because you've been taken to court by how many employees and you are listed. You will not appear as a good employer to most people if you are just there. So you have to be pragmatic about this. That's why it is important to then try to do mediation and early conciliation to try to avoid unnecessary costs, unnecessary expenditure and time in tribunals for rather than taking the time to be productive and make money. But the point here is that the period of negotiation is now extended from 6 weeks to 12 weeks. And again, this one has been advocated for by the trade unions. Previously, if someone went into industrial action, they would be protected for 12 weeks. You could not fire them from work within the 12 weeks after the industrial action, unless if it's for a reason not linked to the industrial action or not remotely linked to the industrial action. And of course, employers would also try to find any other reason which is legitimate to fire the employee, and the employee would say, you're firing me not for that reason, but you're firing me because of my participation in an industrial action. It's an area that you have to approach with very serious caution, because if you fire the person under the circumstances, it's either way that the court can interpret whether you fired them for a legitimate reason or for a reason related to the industrial action that they've taken. But now the 12 weeks have been removed. You cannot fire anyone who has taken industrial action for the reason that they took industrial action. It's now open-ended. You cannot fire them for that unless if it's for a reason that is legitimate, which again, you need to take um, legal advice, whether or not it is prudent for you to take that action against that person, or it might be interpreted otherwise by either the ACAS or the tribunal, wherever they take their case. But that is now the position. The protection is no longer just for 12 months, for 12 weeks rather. It's now for a perpetual period. Um, this one is more on a voluntary basis. Um, no, this one is on a legal basis. So the disclosures about whistleblowing, sexual harassment, the government is taking it very seriously because some of them were being swept under the carpet, some were not being dealt with properly, but the government has now implemented this. So what has changed? Disclosures relating to sexual harassment are more clearly protected. So they're now it's now a protected characteristic, a protected right, increasing the legal risk of retaliation or poor handling. So we need to train our staff. We need to be able to handle when a complaint is made, when there's whistleblowing that has been made, even if the person that is being whistled against is someone that is an employee that you like. And in family-run businesses, there's always a challenge whether if someone reports to the husband or the wife or the son or the daughter or niece, are they going to take any action against whoever is allegedly to have breached the law in terms of sexual harassment? So employers face greater tribunal exposure and reputational risk where complaints are not handled properly. So we need to handle them properly and fairly, and the repercussions, the penalties can be very severe. We need to update our policies to reflect this as well. So there is an ongoing government consultation about CHOP. I've talked briefly about CHOP in my presentation. And if your business is likely to be involved in a chopping exercise anytime soon, or it is your business that you do chopping for other businesses, you need to get involved with the consultation. And as we know, if the government is doing a consultation, the chances are that they are going to implement any changes that they deem fit or necessary. So you can go on the GOV website and look for the links to participate in the consultation that is taking place. It's always important to try to have your voice heard rather than to just complain thereafter when you've not taken any action yourself. This one is more on a voluntary basis, and but for bigger companies, it's on a mandatory basis. But on small companies, it's on a voluntary basis. Employers can voluntarily publish information about the action plans addressing gender pay gaps and menopause support, with mandatory obligations expected for larger organizations or employers. So some businesses, because of history or because of the nature of the work and so forth, in the past have had different pay salaries for different genders and so forth. That needs to be addressed if that is happening in your business. And there is also a movement or an advocacy that is taking place for businesses to recognize the impact of menopause within the workforce. And so it's important to have maybe a menopause policy. What are you going to do if someone is experiencing menopause? Are you going to do reasonable adjustments? Are you going to um, give them time off work and things like that? So you need to consider what you're going to do there. So while it's still not compulsory for small businesses, I think it's something that is important for us as business people to consider. As I have said, a major change is coming again in October 2026. Um, the further package of significant changes will take in that period. So before we get to that period of October, you need to do a gap analysis of your systems, your policies, your management. Do you need to do any trainings, change anything? If you're not so sure, talk to your HR provider, or you can take to talk to town law solicitor so that you can help you to adjust and to be compliant. So what is the impact of the breaches that we do, or we can potentially do as employers? We first increased financial exposure for non-procedural compliance, and there is now more scrutiny from the government, especially under the new agents that they have established, and we might face a lot of litigation because employees have been empowered more than they were in the past. So what you need to do to avoid these things is to review your contracts, policies, staff handbooks, audit your systems such as the payroll, how you allocate your holidays, how you deal with your holidays, the notice periods, the leave records, documentation, record keeping, training, etc. So if we do this, I think we might be able to then avoid any problems in the future. Of course, the problems always come, but we have to do everything possible to avoid them. So as town law solicitors, we can help you with compliance. We can do mock audits. We can help you on record keeping, review your systems, and we establishing ourselves as an expert on Fair Work Agency penal work, where if you are facing a penalty, an investigation, a suspension, and things like that, we are now dealing with those type of work as well. We can help you to review your policies, update your documents, give you training, etc. And as I've said previously, we have got a Breathe HR, our partner that can also help with HR software. So if you need anything along those lines, you can contact us. And we know that maybe you might already have your HR that you're dealing with them. So you might have to see that they are up to date in updating you regarding these changes that have so far been implemented and those ones that are going to happen again in the future. So thank you so much. That is the end of my presentation now. We will then tend to see if there's any questions in the Q&A. Okay, if anyone has got any question, you can just put in the Q&A, or if you have got any question, you can raise your hand. We can keep the next 5 minutes or so for questions. If there's any questions, just raise your hand, and then we can give you the opportunity to ask your question. Okay, it seems like we don't have any questions. Thank you so much for attending. We do a lot of webinars. Some are just specific to our clients that are on our retainer, because we do have retainer packages. Thus, we pay monthly for our retainer packages. We do bespoke for them. If you want those review packages, you can contact me. We'll give you the information. But we will be doing another presentation on the changes maybe that have been done so far by the Home Office, or any challenges with the Home Office in terms of the sponsor license. There's a lot of challenges people that are experiencing, delays in COS, delays in communication from the Home Office, etc. We can have a webinar on that at some point in the future. We'll let you know through the usual channels. Thank you so much for spending this morning to be with us, and have a good day.
Thank you.
Thank you.
Thank you.
Thank you. Thank you.
Thank you.